Welcome to this lecture on WTO Dispute Settlement. My name is Peter van den Bossen, and I am Director of Studies of the World Trade Institute in Bern and Professor of International Economic Law at the Faculty of Law of the University of Bern. Between 2009 and 2017, I served as WTO appellate judge on the WTO appellate body, and I served in 2015 as its chairperson. This lecture is about WTO dispute settlement, and what I would like to discuss with you are the following questions. First of all, how relevant is WTO dispute settlement? You'll see me being very enthusiastic about this dispute settlement system, but is my enthusiasm justified? We'll spend some time on that question. How relevant is WTO dispute settlement? Secondly, we look into what is so special about WTO dispute settlement. Special when you compare it with other state-to-state dispute settlement systems. Third, we will ask ourselves the question, how does the WTO settle disputes? And in answering that question, you'll see that the WTO actually settles disputes in various ways, or at least has various methods of international dispute settlement to its disposal. Four, I want to talk to you about who does what in WTO dispute settlement. In other words, we will look at the institutions and the mandate, the various mandates of these institutions dealing with the resolution of disputes. Fifth, and we're almost at the end of our list, what happens when in WTO dispute settlement? And in answering that question, we'll look at the process of dispute settlement and we'll look at procedures. But I promise you that we will not go into detailed discussions of procedural issues. And then finally, the question, what are the dangers facing WTO dispute settlement? And I would like to note in this context that currently the WTO dispute settlement system is challenged by one of the world's major trading entities. Challenged in a way that has plunged the system into an unprecedented crisis. A crisis that raises questions as to whether the multilateral rules-based dispute settlement system that the WTO dispute settlement system is, whether that system has a future. First, I promised you that I would talk about the relevance of WTO dispute settlement. Is my enthusiasm for this system justified? And what we'll do is we'll look at the number of disputes that states brought to Geneva, to the WTO for resolution. And we'll look at what this dispute settlement system produced, the number of reports. And reports, I'd like you to understand this. Reports is WTO speak for judgments. Don't talk about judgments in the context of WTO dispute settlement, we talk about reports. So we'll first look at the number of disputes and the number of reports. Secondly, we'll look at who were the complainants and who were the respondents, who used the dispute settlement system against whom. Four, we'll look at the agreements, the WTO agreements that were at issue. Was it trade in goods? Was it trade in services? Was it intellectual property law? What were the issues that came up? Which agreements were at issue? And then finally, and perhaps that's the most important thing that we'll look at, is the success of the system. Because any dispute settlement system would not be worth the paper it's written on if there is at the end of the day no compliance with the rulings of the court. There I'll be happy to say that this compliance rate linked to the WTO dispute settlement system is impressively high. Okay, to start with the number of disputes that was brought to the WTO. The system was started in 1995. And so we're looking at a period from 1995 to 2018. Today we're the 6th of February. So in that period, a total of 538 distinct disputes were brought to Geneva for resolution. That excludes 60 disputes that were really about the question whether a country that had been found to have acted inconsistent with WTO law, whether that country had then subsequently complied with the earlier rulings. There are about 60 disputes in addition to the 538 that were original cases. Now, if you look at this statistic, or this graph, it's more a graph, the number of cases that were brought in, you'll see ups and downs. And particularly in the beginning, there are quite impressive ups. They're not really representative. Many of these cases were actually old cases that were not brought in under the old dispute settlement system, but that were brought at the very beginning of the new system. So they kept them in reserve, and that's why the numbers in these early years were so high. But as from 2000 onwards, I think you can say that we have, on average, about 17 cases that were brought. As I said, it goes up and down, and don't ask me why. I have many theories as to, but my theories are as much worth as anybody else's theory. It goes up and down. Yeah. The most important thing, of course, is the total number, 538. And let's keep that number in mind. Now, that's what went into the system. Question is, what did the system produce with all these disputes? And that goes, first of all, to the question, how many reports were produced, how many judgments were produced. At first instance, and we'll come back to that later, WTO dispute settlement is at two instances. The first instance, where you have panels looking at the dispute, what comes out as a panel report, a panel judgment. Panels produced 230 panel reports. The appellate body, who sits in appeal on these panel reports, produced so far, in that period from 1995 to 2018, 133 reports. And I ask you to keep that number in mind, 133. Come back to that later. Now, very typical about WTO dispute settlement is that actually the system prefers you not to go to court. It's one of the features which I'll briefly say more later. It prefers you not to go to court. It prefers you to reach amicable solutions to your dispute. And what is amazing is that in 20%, and that's a fairly high percentage, 20% of the cases, such an amicable solution is found. That can either be in the form of a mutually agreed solution, or it can be that the complainant, after further negotiations, consultations with the respondent, decides to drop the case, 20%. One more word on the number of active disputes. How many disputes are currently, and we're talking the 6th of February 2018. How many disputes are currently before at the WTO? At the very first stage of the process, the consultations, the negotiations, 25 distinct disputes. At the panel stage, and that's the first stage of adjudication, 26. And before the appellate body, at this moment, 7 cases. And also there, I would like you to keep in mind the number 7. The question that I always ask my students, when I say, well, the appellate body produced, over the last 22 years, produced 133 judgments. And there are currently 7 cases before the appellate body. Is that a lot? That's the question. Is that a lot? Should we be impressed? Well, you always have smart students. So they say, well, it depends, Professor. And they're right. It depends. It depends on what you compare it with. If you compare it with the production of the European Court of Justice, this is not impressive at all. If you compare it with national courts, this is certainly not impressive. But you have to compare it with things that are comparable. And what is comparable? Well, other state-to-state courts and tribunals. Such as, of course, the first thing that we think about is the International Court of Justice. Now, I told you that the appellate body produced 133 appellate body reports over the last 22 years. What did the International Court of Justice produce? Well, they produced 70 judgments and 6 advisory opinions. So let's take these two together. 76 versus 133. Pending cases, and I checked this yesterday on the internet, pending cases, 14. But none of them is currently being heard or under deliberation. So, just as an aside, the International Court of Justice has 15 judges. I'll tell you later that the appellate body has 7 in good times, and we're not in good times at the moment, but should have 7. And that in terms of budget, the budget of the International Court of Justice is 250% bigger than the budget of the appellate body. 67, sorry, what do I say? 76 judgments by and advisory opinions by the International Court of Justice as compared to the 133 reports by the appellate body. Let's look at another court, another tribunal, and perhaps even that is even a better comparison, because while the International Court of Justice has jurisdiction over the whole of international law, WTO only has jurisdiction over a part of international law, international trade law. So let's compare it with another court, another tribunal that has limited jurisdiction in that sense, such as the International Tribunal on the Law of the Sea, ITLOS. 21 judges, a beautiful customs-built courthouse in Hamburg. Do you hear the jealousy in my voice? What did they produce? Since 1996. They started a year later than the WTO Dispute Settlement system. Judgments, 22. And 2 advisory opinions. Pending cases, 1. Now, a court lawyer would say, I rest my case. But it's not that simple, of course, because there are those that would argue, well, yes, but, I mean, the International Court of Justice deals with important matters. Important matters. While the appellate body deals with very, very technical trade matters, which are of interest to a very small group of people. They're of little interest to the general public. I would say that There are definitely appellate body cases or cases that went to the appellate body that are extremely technical and, I admit, extremely boring. But there are also many others. There are quite a number of disputes that went to the appellate body that concern, for example, national legislation, national measures for the protection of the environment. Examples, the US shrimp case, the Brazil retreaded tires case, the US tuna case, the Canada renewable energy case. All these cases concern national legislation, national measures for the protection of the environment. There are also quite a number of cases that deal with national legislation, national measures for the protection of public health. The E.C. Hormans case, the E.C. asbestos case, the U.S. clove cigarettes case. There are cases that dealt with national legislation, national measures for the protection of public morals. And you will immediately see that these are highly sensitive issues. Public health, protection of the environment, protection of public morals. These are very sensitive cases which obviously generate much public attention. I could go through a number of other cases. There are cases that dealt with what I would call foreign policy. The cases that deal with agricultural policy, which is all, in many countries, a very sensitive thing. Industrial policy. What are the Airbus and Boeing subsidy cases? What are they about? They're about industrial policy. There's cases about the sovereignty over natural resources. The China raw materials case, the China rare earths case, and there are cases on measures that are taken to fight climate change. So my point here is that many of the cases that are brought to the WTO dispute settlement system and that end up at the appellate body when there is an appeal, that many of these cases deal with politically very sensitive issues, do not just deal with extremely technical issues such as the calculation of an anti-dumping margin, which happens to be a very sensitive issue in some capitals, but most people will not lose much sleep over that. But they will lose sleep over measures for the protection of the environment, measures for the protection of public health, and so on. So I come back to the comparison in terms of production. The appellate body has been, and with it the whole dispute settlement of the WTO, has been very productive. Point one. Going to the second point, as to the relevance of the system, who has used the system and against whom. Looking at who the complainants have been over the period of the last 22 years, it is quite striking that, but not surprising, that the United States has been the most active user of this dispute settlement system. 21% of all the cases that were brought to Geneva were brought by the United States. A close second here is the European Union, with 18% of the cases. And then you've got the other high-income countries with 19%. And then there's the whole group of developing countries, which includes upper middle income, lower middle income, and low income countries, 42%. So 42% of the cases were brought by developing countries. I have to admit that this data, and you may now see the graph, is somewhat misleading. Why is it misleading? Because it goes over the whole period of the 22 years. And there was, in the first years, there was really an overrepresentation of the case, well, overrepresentation, now that was a negative term, but there were many, many cases that were brought by developed countries. If you look at and that's the next graph, if you look at basically cases brought as since 2000, in many years, developing countries brought more cases to the WTO dispute settlement system than developed countries did. Yeah? And I think this is clearly illustrated by the graph that I think you will see now. Just one more thing about the complainants. There was, as I said before, 5% of the cases was brought by low-income countries. That was primarily, in those 22 years, that was primarily India, which during a long period in those 22 years was still a low-income country. It has now graduated to the category of lower middle income. But so a lot of these low-income country cases, that was India. There has only been one case ever brought by a least developed country, Bangladesh. Bangladesh brought once a case against India on anti-dumping duties on batteries. So the use of the system by least developed countries has been very limited. Going through the list of the top 10 users, you will see, as expected, the US on top with 115 cases, then the EU with 100 cases. Canada is third, Brazil is fourth. So the first developing country, biggest user of the system is Brazil, 31 cases. Mexico, fifth. India on the sixth place, and so on. Yeah? In the top 10, you find 5 countries that everybody would agree to are developing countries. Respondents. Yeah. Whom were the cases brought against? And you sometimes have the impression that in certain circles, they describe the WTO dispute settlement system as a system that is used by developed countries against developing countries to enforce the obligations. And if you look at the graph, that I think you'll now see, this is not the case. Yeah? Because actually most cases have been brought against the United States. Remember, it's the member that brings most cases, but it's also the member against whom most cases were brought. 24% of all the cases are cases against the United States. If anybody wonders why the WTO dispute settlement system may not be that popular in Washington, then that's probably one of the reasons. Because many cases are brought against the United States too. The European Union here is a distant second with 19%. Well, not that distant, but not very close either, 90%. Then you've got other high-income countries, 14%. All the developing countries together, as the respondent, make up for 43%. It's actually, you have WTO dispute settlement in all sorts of relations. You have it developed country against developed countries. And yes, there are quite a number of cases. Example, the Boeing and Airbus cases. The United States against the European Union, the European Union against the United States. A number of these cases. You've got cases of a developed country against a developing country. Yeah, they also. Most recently, the India solar cells case. Developed countries brought that case against India. You've got cases of developing countries against developing countries, and you've got quite a number of those, where developing countries use the system to settle their trade disputes. You actually see that also, for example, in Latin America, that Latin American countries use the system a lot to settle disputes among themselves. But my favorite sort of combination is a developing country against the developed country. Yeah? And within that category, my real favorites are the David versus Goliath cases. Yeah? Examples, Costa Rica versus the United States in the U.S. underwear case. Now, I don't invent the names of these cases, but this case is U.S. underwear. Small Costa Rica, beautiful Costa Rica, but small Costa Rica, brought a case against the United States in the early years of the system, and it won hands down. Yeah? Things that they could not achieve diplomatically were won and the United States withdrew the measure even before the appellate body was ready with its final pronouncement on that dispute. Even more, David is a case called U.S. gambling. That was a case brought by Antigua and Barbuda. At the time, 90,000 inhabitants. And they bring a case against the United States. It's rare in international relations that might is not always right. And that is quite clear here. Okay, enough said about who the complainants were and who the respondents were. Let's go to, well, I've got here also an overview of who were the top respondents. Again, United States, European Union. China comes at the third place. A large number of cases has been brought against China. And the number is impressive because China only joined the WTO 6 years later than the WTO Dispute Settlement system started. India on the fifth place, Argentina, Canada, and so on. Yeah. Again, 5 developing countries, 5 developed countries as the most frequent respondents. What have been the agreements at issue, the WTO agreements at issues in all these disputes? Let me not be too technical here, because after all this is a lecture on dispute settlement and not on WTO law sec. But it's perhaps useful for you to know that in most disputes, there was the claim was made that there was a violation of a GATT article, so the Basic Agreement on Trade in Goods. And that's the biggest category, as you can see on the graph. Other popular agreements to bring cases under have been the trade remedy cases, the trade remedy agreements, the subsidies agreement, which is identified there as SCM, Subsidies and Countervailing Measures Agreement, and the Anti-Dumping Agreement, ADA. What is surprising is that there have been, or some would say it's surprising, that there have been relatively few cases under the GATS, the General Agreement on Trade in Services, and under the TRIPS agreement. Why is it surprising? Because often we think of WTO law as having 3 pillars. The goods pillar, the services pillar, and the intellectual property pillar. Now there has been a lot of disputes under the goods pillar, and much, much less under the other 2 pillars, the GATS and the TRIPS agreement. Now, there are reasons for this, but that would lead me too far. Now, before I go to what I think is the most important thing in terms of a dispute settlement system, and that most important thing is that I already indicated is compliance. Is there compliance with the rulings? Before I talk about that, I want to say one thing about how often a complainant wins a case in the WTO. And it's useful to indicate that because it's quite amazing that the success rate of complainants is so high. As you can see on the graph, the success rate for complainants is almost 90%. So in almost 90% of the cases that are brought to Geneva for resolution, the complainant wins on at least one claim of inconsistency. These days, most complainants have a machine gun approach to litigation. They file one claim of inconsistency after another, after another, after another. They don't use the golden bullet approach, but machine gun approach. In most cases, well, not most cases, in almost 90% of the cases, at least one of these claims of inconsistency will stuck. That's impressive. Yeah. That's impressive. Now, does that indicate a certain bias of the system for the complainant? I don't think so. I think it's more a reflection of the fact that before actually bringing a case and bringing it to the panel stage, countries WTO members have thought it through very, very carefully. They don't bring frivolous cases. The frivolous cases, if there are any, they're weeded out in the consultation stage, or they're not brought at all. So it's more a question of the self-selection that takes place in the kind of cases that is brought. Yes, let me now come to what I think is I'm repeating it for the third time, I think now, one of the most important things of any dispute settlement system is compliance. Yeah? Does the country that is found to have acted inconsistent with its international obligations, and in this case WTO obligations, does that country then subsequently change its law, withdraw the measure, puts itself into consistency? In the case of the WTO dispute settlement system, there is a compliance rate of 85%. Now, different scholars will give you different figures, but it's between 80 and 90. So I put myself in the middle. That is very, very impressive in terms of compliance with WTO rules and recommendations. It's very impressive. Very few national dispute resolution systems, court systems, have as high a compliance rate as this, let alone other state-to-state dispute settlement systems. And I will not in this context refer to the International Court of Justice. I hope I've done one thing so far, and that is to convince you that the WTO dispute settlement system is relevant, and is as relevant, is as important, is as successful as I think it is, and I claim it is. So you've got much use of the system. You've got 538 cases brought thus far. You've got much production. You've got the appellate body producing 133 reports, judgment. Is that a lot? Well, we've gone through that discussion. You have broad use. Both developed and developing countries use the system, and in all sorts of combinations. It is used over a wide variety of different agreements. And there's a high compliance record. I rest my case. Yeah. What I would like to do in the second part of the lecture is to try to answer where does this success come from? Yeah? Why is the WTO dispute settlement system successful in the ways I've described it? And I think also keeping in mind the time limits, I think I'll focus on the following aspects. First of all, I want to tell you a little bit about the origins of the system. Where does the system come from? Because it's important to understand that. Why we have the current system and not another system. So, origins. Secondly, I'll talk a bit about jurisdiction. Thirdly, about access to the system, who has access to the system. Fourthly, I'll talk about key features, and key features will group a number of things that I can't put elsewhere. Last but one, I'll talk about institutions, and then finally, I'll conclude this section before looking into the future. I'll talk about process. Origins. I already said that the current system is functional, is operational since the 1st of January 1995. It came about at the same time as the WTO, as an organization became operational. But did that dispute settlement system that we're now describing, did it fall out of the sky? Did it come out of the blue? No. It was actually built upon a dispute settlement system that had existed under the GATT, the General Agreement on Tariffs and Trade, the predecessor of the WTO. And that dispute settlement system of the GATT was itself a very, very interesting system. It started in 1947, 48, when the GATT became provisionally applicable. It started out there as a power-based diplomatic dispute settlement system. Power-based diplomatic dispute settlement. You don't even find a title in the GATT that says dispute settlement. There's an Article 22 and an Article 23, but they do not refer to dispute settlement. It's really very, very rudimentary in terms of a dispute settlement system. But they built upon that, and gradually, over the years between 1948 and the establishment of the WTO, that system transformed itself into a rules-based, quasi-judicial dispute settlement system. And it would take me much too long to explain what the various steps were, but take it from me that this evolution took place. But there was one, well, perhaps a number, but there was one very, very important problem with that GATT dispute settlement system. And that problem was that the reports that were produced by panels of experts, that these reports only became legally binding when they were adopted by consensus by the GATT contracting parties. And you've heard it well. So the reports had to be adopted by consensus, meaning that also the loser in a case had to agree to the report in order for it to become legally binding. Now, believe it or not, but for many years, that system worked. And it partly worked because these reports, and I would invite you to read some of these old reports. I mean, they're fun to read. They don't read like judgments. They read like diplomatic compromises. And therefore, it was possible for the losers to sort of agree to it, and then that became legally binding. Now, with the evolution that I described, from a power-based system to a rules-based system, with that evolution, the reports, the panel reports, became more and more legally focused and became harsher in their language. And that made it very difficult for the loser to actually agree to these reports. And what we've seen, and that led to the breakdown of that GATT dispute settlement system in the 1980s, the reports, many reports, didn't get adopted anymore. Yeah? So they didn't become legally binding. Which the United States then said was a justification, and I suppose under general international law they have some good cause for saying that, saw it as a justification to, since there was no functional multilateral dispute settlement system, they said, well, you don't give us any other choice but to go unilateral, and to decide unilaterally who violates the rules of the GATT. And if they found a country to have violated the rules of the GATT, they imposed unilaterally, again, sanctions on that. It is that American unilateralism that that really blossomed in the late 80s because there was no functional multilateral dispute settlement system. It is that U.S. unilateralism that brought the GATT contracting parties around the negotiating table in order to negotiate a new dispute settlement system. And that new dispute settlement system was part of the agreements that concluded the Uruguay round. That new system was set out in the DSU, the Dispute Settlement Understanding, so the Agreement on the Resolution of Disputes. That system has been described by my predecessor as European Appellate Body Member, or Appellate Body Member from the European Union, Professor Klaus-Dieter Ehlermann, as something close to a miracle, and I think he's right. The fact that we had this dispute settlement system that I will briefly describe later in its various features, it's unique in terms of international dispute settlement. It has features that you don't find anywhere else, at least not that combination of features you don't find anywhere else. What explains the miracle? I think at that particular time in history, the wish to step away from unilateralism and to find a functional dispute settlement system, multilateral dispute settlement system. And one of the things two important innovations, not many innovations, but two very important ones. One was to fix the main problem in the old GATT dispute settlement system. You'll remember that I said the main problem there was that the reports, panel reports, had to be adopted by consensus. So anybody could block the adoption of the reports. Meant anybody could block these reports to become legally binding. That problem was resolved by a new rule, namely that panel reports would be adopted, or ought to be adopted, by what we call reverse consensus or negative consensus. And it's requires a bit of brain gymnastics to understand the concept of negative consensus, but it comes down to the report is adopted unless there's a consensus not to adopt it. Well, I can tell you that the winner in a case is never going to join a consensus not to adopt the report. And has there ever been such a consensus in the last 22 years? No. Obviously, perhaps not obvious. Theoretically, it's of course possible, but it has not happened so far. That's one important innovation. The other important innovation is, after they had decided that panel reports would be then adopted by this a negative consensus, this reverse consensus, so quasi-automatic, I think the negotiators had what I like to describe, they had an oops moment. Oops, what did we do? Because such a panel report can be a very bad report. I mean, occasionally they're very bad panel reports, and we would no longer have any control over that because they would be quasi-automatically adopted and become legally binding. This is when they realized that they probably needed an appeal stage. And that's when the appellate body came into play. And as I've written in publications before I became an appellate body member, it really was, and once one looks at the negotiating history, it was an afterthought. There was not this idea of constructing a clear hierarchy with the appellate body on top and then panels under. It was more like panels here, and then in exceptional cases, you have to have the possibility to appeal bad panel reports. Now, as from the very beginning, it turned out differently, because for the first 2 years and a half, up to the Japan film case, all panel reports were appealed. Everything was appealed. Okay, so This is to explain a bit of the origins. So the GATT dispute settlement system and the new system, quite a miracle actually, fixed the defaults of that original system and really introduced a multilateral, rules-based dispute settlement system instead of unilateralism, unilateral resolution of disputes. Let me go now quickly through a number of other features. And first of all, jurisdiction. The nature of that jurisdiction? Well, I like to describe it as CEC, CEC, compulsory, exclusive, contentious. The jurisdiction is compulsory. If a case is brought against you, you can't run away. You cannot deny the jurisdiction. You have to. The fact that you're a WTO member makes that you have to submit yourself to the jurisdiction of the WTO Dispute Settlement System. Again, if a case is brought against you, you have no choice but to accept the jurisdiction. That's very, very different in other state-to-state, most other state-to-state dispute settlement systems. So compulsory jurisdiction. Exclusive jurisdiction. Exclusive jurisdiction goes to the fact that disputes relating to WTO rights and obligations can only be brought to the WTO dispute settlement system. So you can't bring a dispute, at least not under WTO law, you can't bring a dispute on Article 3.4 of the GATT, national treatment. You can't bring that to the International Court of Justice. You have to bring the exclusive jurisdiction of the WTO dispute settlement system. And then last, the jurisdiction is contentious. The WTO dispute settlement system has only contentious jurisdiction, as opposed to what? Well, it doesn't have advisory opinion jurisdiction. As to the scope of jurisdiction, well, I think I've already mentioned that all disputes that relate to all but very, very few WTO agreements, all these disputes would fall within the scope of the jurisdiction of the WTO dispute settlement system. So that goes from customs duties to intellectual property rights, that goes from quantitative restrictions to sanitary and phytosanitary measures. There's an awful lot of different disputes that can be brought to WTO dispute settlement, and this is also something that makes it a fascinating field to be active in, because you get all sorts of different cases thrown at you. With regard to the measures that are subject to WTO dispute settlement, it's perhaps interesting to see that it's not only measures that are actually applied that you can challenge, but you can also challenge a measure or legislation without it being applied. So then you talk about an as such claim. So you're not focusing on the fact that that legislation was applied in a particular circumstance, but you're just focusing on the WTO consistency of the legislation as such, without having to look at the way in which it has been applied. So that's one. Measures can obviously be legislation, but they can also be just acts, but also practices. You can challenge practices. You can challenge unwritten measures. You can challenge measures that no longer exist. As long as they were in existence at the time that the panel is established, that's enough. That allows you to bring it to... Let me go on. That's about all I want to say about jurisdiction. Access. Who has access to the system? Who can bring WTO cases? Members, and members only. Individuals, companies, other international organizations cannot bring cases to the WTO. They do not have a right of recourse. There's one very peculiar thing, which in a way is somewhat theoretical, but still it's interesting to mention. In order to bring a case to the WTO, you do not necessarily need to claim that there has been a violation of WTO law. What matters is whether there has been a nullification or impairment of a benefit that you get under one of the agreements. Now, in most cases, 95%, 98% of the cases, that nullification or impairment is the result of a measure that is WTO inconsistent. And then you talk about violation complaints. But it is possible to bring a case where you say, no, I'm not arguing that this measure is in itself a violation of WTO law, but the measure does nullify or impair one of the benefits that I have under the agreements. And these are called non-violation complaints. As I already indicated, these non-violation complaints are limited. There are few of them, and under the WTO, in the WTO years, as opposed to the GATT years, in the WTO years, none of these non-violation complaints has been successful. But it's a rare feature of the system. So normally, in most court systems, you have to argue there's a violation of the law. In the WTO, at least theoretically, you don't have to argue that. You can also bring a case when you merely argue that there's nullification or impairment of benefits. I said that the system was only accessible for WTO members. And I'm not going to withdraw that statement. But there is something that I like to call indirect access to WTO dispute settlement. And the best way of expressing that would be to say, behind every case, there is an industry association. There is a big company. There is an NGO. Countries do not bring cases just because they like to bring cases. Countries bring cases because their industry, their big company, their NGO has lobbied the government to bring that case. And this is what I call indirect access, and in some countries that sort of indirect access is highly regulated and organized. In the European Union that's the case, and that's the trade barriers regulation. In the United States that's the case. That's Section 301 of the Trade Act. In other countries it's less regulated. But you will find that behind most cases, the vast majority of the cases, there is a company, an industry, or other interest behind. So, indirect access. Key features. First key feature worth mentioning would be prompt settlement of disputes. And that is not surprising. That is a key feature of the system. They want to settle disputes promptly. You find that expressed in Article 3.3. By the way, if you don't, I sometimes call upon students to read the Dispute Settlement Understanding. Not a very long agreement, but still, it's an effort. And I know that you may not want to do that, to read that from Article 1 up to Article, 27, 28. So you don't, but if you read anything, read Article 3. Because Article 3 really will give you most of the key features of the system. And the prompt settlement of disputes is like the first one. That's Article 3, paragraph 3. Second key feature is set out in Article 3, paragraph 2, first sentence. And that goes as follows. The dispute settlement system is a central element in providing security and predictability to the multilateral trading system. And that says a lot. Why do we have dispute settlement? To provide security and predictability to trade, to the trading system, to the multilateral trading system. Article 3, paragraph 2, first sentence. Article 3, paragraph 7, and we already briefly touched upon that. There's a preference for mutually agreed solutions. There's a preference not to go to court, not to go to panels, not to go to the appellate body, but to negotiate resolutions amicably, to reach an amicable solution. Article 3, paragraph 7. And that is successful. I mean, remember the 20% success rate? And now, of course, in other dispute settlement systems, before you bring a case to the court, you have to try to settle through negotiations. But the difference with the WTO dispute settlement system is that it is part of the system. You can't bring a case to a panel before you have, for at least 60 days, tried to negotiate an amicable solution. Different methods of dispute settlement. The DSU, the Dispute Settlement Understanding, provides for all of them. Yeah? It provides for consultations, negotiations in Article 4. That's the very first step always. It provides for adjudication. What happens before a panel, what happens before the appellate body, that's adjudication. But it also provides for arbitration under Article 25 and a number of other provisions. It provides for good offices, it provides for mediation, it provides for conciliation. Now, the latter four, arbitration, good offices, mediation, and conciliation, have not been used very often, and that's an understatement. They have been used very little. Most of it has been, obviously, always as a first step, consultations, negotiations, and then adjudication by panels and the appellate body. But I think it's worth mentioning this because when people think about a WTO dispute settlement, they only think about panels and the appellate body. No, the DSU itself also provides for other methods of international dispute settlement. Back to Article 3.2, but now the second sentence. What does that say? That the dispute settlement system is there for the preservation of the rights and obligations of its members. Now, I think most dispute settlement systems would say that. Yeah? It's there for the preservation of rights and obligations. So that's not that surprising. But then it goes on, the same sentence, and it says, the dispute settlement system is there for, panels and the appellate body are there for clarifying existing provisions of the covered agreements, of the WTO agreements. Now, that's interesting. Clarification, the mandate to clarify. Why is that interesting? Because as many other international agreements, the WTO agreements are beauties of constructive ambiguity. And am I holding this against the negotiators? No, not at all, because if the negotiators would have wanted to have clarity on everything, they would still be negotiating the WTO agreements. But they are beauties of constructive ambiguity, so there's a lot of need for clarification. So does that create the danger of judicial activism? Well, the drafters of the DSU were very aware of the fact that if you allow a judicial or adjudicative body to clarify, and then there is this danger of judicial activism. And that's why they said twice, not just once. It's a short agreement, the dispute settlement understanding. They say twice that panels and the appellate body, the dispute settlement system as a whole, may not add to or diminish the rights and obligations of members. They don't use the terms of judicial activism, they don't. But this is a clear statement against judicial activism. You shall not panels and the appellate body, you shall not add to or diminish the rights and obligations that members have under the agreements. They say it twice, once in Article 3.2 last sentence and once in Article 19 second paragraph. Now, Article 3.2 is also helpful because they indicate how the appellate body, panels before that, how they are to avoid adding to the rights and obligations of members or diminish these rights and obligations, how they are to avoid judicial activism. What does Article 3.2 say? It says that this clarification has to be done according to customary rules of interpretation of public international law. And that has been seen as a reference to Articles 31 and 32 of the Vienna Convention on the Law of Treaties. And again, that is a lecture in its own right. So I'm not going to go into this. But the appellate body has done that very, very carefully. Some commentators would say actually been overly textual. Text which is obviously put in context and then read in the light of the object and purpose of the agreement. The appellate body has been very, very careful to stick to that mandate. That does not prevent some members to consider the appellate body as guilty of judicial activism. Let me only say that judicial activism is often in the eye of the beholder. Yeah? I have never heard the winner in a case to accuse the appellate body of judicial activism. The winner of a case winner of a dispute always says, oh no, that's what the law already said, that's what we argued. Yeah? Losers often have a different story. So judicial activism is in the eye of the beholder. Last comment on basic features goes to the remedies for breach. The remedies for breach of WTO law. There's actually only one final remedy. This is often misunderstood, but the text of the DSU is quite clear on this. There's only one final remedy, and that is the withdrawal or modification of the measure, the legislation, the act that was found to be WTO inconsistent. And you have to do that promptly or within a reasonable period of time. And get me too far to explain what the reasonable period of time is, but that's, a reasonable period of time is being determined. Either parties agree on it, or there's an arbitrator that will fix that reasonable period of time. So, only final remedy is to get your legislation to make it WTO consistent. There are two intermediate remedies: compensation and retaliation. Compensation can be offered by the respondent and has to be accepted by the complainant when withdrawal of the illegal measure is not immediately possible. Then the respondent can offer compensation. Compensation, for example, in the form of lowering customs duties on another product that is of export interest. That is of export interest to the complainant. That may be compensation. Has happened in very few cases, very, very few cases, that compensation was offered and accepted. The other temporary remedy is retaliation, is the imposition of trade sanctions. And that is that has happened in a few more cases where for example, in the Holman's case, the case brought by Canada and the United States against the European Union, the European Union failed to comply with the rulings and recommendations of the appellate body in that case, and as a reaction, the United States and Canada imposed trade sanctions on the European Union. You have to be authorized by the dispute settlement body to impose these trade sanctions, but again that authorization is given by reverse consensus, so it's quasi-automatic. Let me emphasize again that both this compensation and this retaliation are just temporary remedies. You're waiting for the withdrawal of the illegal measure. So it's a temporary remedy. The only other comment I want to make on remedies is that there's one very important thing missing in this remedy set, and that is there is no compensation for injury resulting from the breach of WTO law. Now, let's say you just mentioned compensation. No. Compensation I mentioned is for to compensate the damage that will arise in the future. After the judgment, after the ruling that says the measure is WTO inconsistent, damage that is caused then in the future, that can be compensated for as long as necessary until the time that the measure is then changed, the legislation is changed. What you don't have is compensation for the damage that was caused in the past by the illegal measure. And that is sort of strange because under customary international law, you have to compensate damage that is caused by an illegal act. But the WTO dispute settlement system has contracted out of this rule of customary international law through the DSU, which provides for its own set of remedies, and that remedies, all these remedies are prospective. Yeah? Nothing is done about the damage that is caused in the past. And that's sometimes said as one of the major shortcomings of the dispute settlement system is that you don't have compensation for damages caused in the past. I'm making progress. Let's now briefly talk about who does what in WTO dispute settlement, so in other words, the institutions. And I think I've already mentioned some of them, but you basically have two kinds of institutions, and that in itself is a bit strange too. You have political institutions, and one in particular, the dispute settlement body. The dispute settlement body is composed of all WTO members. And they actually take key decisions. There's a key decision on the establishment of panels, because as we say in a minute, panels are ad hoc, so they have to be established in a particular dispute. That is a decision that is taken by the dispute settlement body, the political body. They take the decision on the adoption of the report, making it legally binding, and they take the last decision that they take is the decision on retaliation. But they take these decisions, as I already explained before, by reverse consensus. Yeah? And don't torture your brain on this. Reverse consensus means de facto quasi-automatic, if not automatic. Yeah? So yes, they take these crucial decisions, but they take them by reverse consensus, so it's quasi-automatic. Is that then still useful? Yes, I think it's very useful to have the dispute settlement body, the political body, take all these decisions, because it keeps the organization very much aware on what disputes are ongoing. This is very different. I mean, at one point I also worked with the European Court of Justice, and there you really had the impression that there was the world in Luxembourg, where the European Court of Justice is, and then there's the world of Brussels, where the political institutions are, and they were far apart. At the WTO, since the political body the dispute settlement body, is involved in every stage of all the disputes. The beginning, then the adoption of the reports, and then finally both panel reports and appellate body report need to be adopted, and then finally, if it comes to that, the authorization of retaliation. It follows up the whole process, which I think is very useful. Okay, that's the dispute settlement body. That's the involvement of the political side of the organization. And then you have the adjudicative part of the organization, with at first instance you have panels, the ad hoc tribunals, so they're established for every dispute. And they're composed of 3 trade experts, quite often trade diplomats based in Geneva, or trade specialists from capital. A fair number of law professors or practitioners, but the majority still are either current or former trade diplomats of countries that have no link with the dispute, that are neither a party or a third party in a particular dispute. And then finally, you have the appellate body. The appellate body that sits in appeal on panel reports, on panel rulings. The appellate body, unlike panels, is a permanent body. It's a permanent appeals tribunal of 7 judges. Not at this very moment, because appellate body members need to be appointed by consensus, and that is a normal consensus, so that gives every country a veto power. And the process of appointing new appellate body members is currently stuck, and the number of appellate body members is down to 4. There are only 4 appellate body members at the moment in function as members of the appellate body. So the picture that you may now see, which still has 6 appellate body members, there was already one that had retired at that moment. That picture is no longer correct. The gentleman in the middle, that's me. I retired from the appellate body in December last year, and then the gentleman in the corner, Ricardo Ramirez from Mexico, he retired already last summer. At this moment, there are only 4 members on the appellate body. The appellate body reviews only issues of law. We don't review the issues of fact. But again, let me not dwell on this. I could talk for a very long time on this. I think, if you think about the appellate body, I think it's fair to say that it has all the features of a court. And the fact that it's called appellate body is itself testimony of its very modest origins and somewhat misleading. Okay, last point before I come to a conclusion, something very quickly about the process. And again, I think I've said most. The steps in the process of WTO dispute settlement, you always start with consultations, negotiations between the parties in order to reach a mutually agreed solution, if at all possible. Once you've done that for at least 60 days, but often parties take longer, if you've done it for at least 60 days, the complainant can then say, well, we will not be able to find a solution to the dispute. We go to adjudication. Then they ask for the establishment of a panel, and the panel process starts. The panel process will start, and eventually that comes out in a panel report, and that panel report can then be appealed to the appellate body, and that's the third stage. And then finally, as a last stage, after the appellate body, when there is an appeal, after the appellate body has come to its conclusion in the case, the fourth stage starts, and that is implementation and enforcement. And one of the interesting things with regard to the latter stage is that again the political body comes into play, not only to authorize retaliation in the end, but also to monitor the compliance. You will find, if you look at the agenda of DSB meetings, every agenda will have, there was this ruling in this case, what has the respondent done in order to put itself into compliance? So there's really a following up, which is, I think, very, very useful. So 4 steps. Consultation, panel process, appellate review, and then implementation and enforcement. 3 brief comments, general observations on the process. First, time frame. The time frames for WTO dispute settlement are short, very short, but always too long. What do I mean by that? Well, remember that I said that there was no compensation for damages suffered in the past. So every day, every month, the dispute settlement process lasts is a day of damage to a national industry, to a company that will never be compensated. So the time frames are very short. A panel should do its work, depending on what you take as a starting point and an end point, should do its work in 6 months to 9 months. That's extremely short. The appellate body, on paper, shall not, the process shall not exceed 90 days. Now, that's no longer realistic, but what the appellate body does take from that is the absolute requirement to do it in as short a time possible. If you compare the statistics, WTO dispute settlement system goes very, very fast. Take an average case before the International Court of Justice, and I think the last statistics say that it's between 3 and 4 years. WTO dispute settlement is much shorter. That's the first thing, time frame. Second, confidentiality and transparency. We've seen a real evolution there. There used to be a lot of confidentiality and lack of transparency. You would know when a case starts, and then it would go underground during the consultations, negotiations. Well, that's normal. And then you would know when a panel is established, requested and established, that was public. But then the whole panel process would be behind closed doors. Then there would be a panel report, that would be public. That would be appealed, also that is public. But then the appellate body process, again, was behind closed doors. So there was a lot of confidentiality and a lack of transparency. And I think there's much more openness now. And I won't go into detail here, but certainly when the parties agree, and most developed countries, if not all developed countries, agree to that. If they have a dispute among themselves, they will agree to public observation. They will agree to the public witnessing the proceedings. It's not as exciting as it sounds. I remember the first time that the appellate body allowed for public observation, and there was a lot of interest on the first morning, and by noontime there were already fewer people. The second day morning, even fewer people, and then at the end of the hearing on the second day, the only people that were still watching, and I'm exaggerating a little bit, but the only people watching were students that had been forced by their professor to attend the hearing. But it's important to do it because it contradicts the stories that are otherwise out there, that all sorts of unholy things happen behind the closed doors. These hearings are at the panel level, but definitely also at the appellate body, are extremely technical. So unless you know the case inside out, you probably are not going to have much fun. If you do know the case inside out, it's great fun. So that's and the last point, of course, is due process and good faith. Due process is extremely important in the whole process of WTO dispute settlement, and is being emphasized again and again. And the system has to be used in good faith. So panels and the appellate body have acted against using procedural techniques to frustrate so things that may be done in national court proceedings are not welcomed in WTO dispute settlement. This brings me to my conclusion. And the conclusion relates to the dangers facing WTO dispute settlement. And I'm going to talk about four things. Four dangers, or perceived dangers. And the first danger is that the system gets overloaded. That too many cases come to WTO dispute settlement. And you may be slightly surprised that I mentioned this, because if you remember the graph that I showed you in the beginning, the number last year was 17, the year before that was also 17 cases. You'd say, well, if you compare that goes up and down. 17, is that really that much? But that is a misrepresentation actually of the reality, because yes, the number is 17, but what we've seen over the last years is that the number of claims in these cases, the number of complainants, the number of third parties, the nature of the measures, that all has exploded. And obviously, our case law is now massive. So there's a lot that needs to be said about each of the claims. I remember the old days, the very beginning of the system. I worked for the appellate body secretariat, and then I went to academia for 10 years to come back as a judge. But in the very early years, we had cases that at the time we thought were complex and big, but they were relatively simple because there was very little case law. Now you have tens of thousands of pages of case law that always needs to be taken into account. So, first danger is to overload the system, especially given the limited means of the system. Second danger is any attack on the impartiality and independence of the arbitrators, the judges, the panelists. A dispute settlement system of this kind, and I think any dispute settlement system, cannot survive if the stakeholders don't have absolute confidence in the impartiality and independence of the judges. And there have been some incidents in recent years that make one worry about whether all WTO members share this need to ensure the impartiality and independence of judges. Third point, that's an even more general point, and in a way it's related to the first point, the overload, the danger of overload, is the institutional imbalance that we see in the WTO. Institutional imbalance between, on the one hand, the rule-making, the legislative branch of the organization, where new rules of international trade are negotiated and agreed upon, and the adjudicative branch, the judicial branch of the organization. Now, the WTO, while there have been successes on the, often not enough focused on, but while there have been some successes on the rule-making side, on the whole, that part of the organization has not lived up to its expectation, has not functioned well. On the other hand, WTO dispute settlement has been very successful. That's what I tried to describe in the first part of the lecture. This imbalance is dangerous, because it also makes WTO members that know that they will not get a negotiated new rule try to use the dispute settlement system to create new rules. And that's, of course, what a dispute settlement system is not about. Not about you making, because then you get into judicial activism, which is my last danger. Obviously, as a former appellate body member, you will not hear me say that the appellate body has been guilty of judicial activism. I honestly believe that that is not the case. But this allegation has been made, and this is a true danger for the system if it's something that absolutely has to be avoided, judicial activism. As I said, I think in the very beginning, and as I slightly clarified later, the system, and that will be my concluding words, the system, the WTO dispute settlement system is currently going through a very difficult period. There are currently only 4 of the 7 appellate body members on the appellate body. The appointment of 3 new appellate body members is blocked in the DSB. This reflects a deep crisis, and in order to deblock the crisis, a very important WTO member insists that systemic concerns that that member has with regard to the current system are addressed. It's not quite clear what that is. I mean, it obviously has to do with judicial activism, perceived judicial activism, but it's not quite clear at this very moment, and we're now speaking February 2018, how we will come out of this crisis. But what is very clear to me, and I hope that this is something that is shared by all that listen to this lecture, that this world, this globalized world, cannot be without a multilateral, rules-based dispute settlement system. You can't have countries decide on a unilateral basis what is right and wrong in international trade. You need a dispute settlement system. And I think that we have currently, we have a very good one. That in terms of international dispute settlement has unique features that has proved to work very well. I very much hope that the system will be allowed to further function and prosper. Thank you.